UK immigration shakeup. What the white paper means for you. What is the 10-year ILR rule? Why legitimate expectations argument is dead for existing skilled workers who will be put on the 10-year ILR route. What is the new standard for the English language requirements? A shorter stay for the graduate route visa holders. In this video, I am going to address all these questions and all other important changes proposed by the immigration white paper. Hello everyone, this is Sachin Sawant, your UK immigration lawyer. And today we are diving into some really significant news that has the potential to reshape the UK immigration landscape. You know, immigration policies can sometimes feel like a constantly shifting puzzle. And just when you think you got a hand on it, new piece arrives. Well, we've got a whole new set of pieces to talk about. On 12th May 2025, the UK government published a crucial white paper titled Restoring Control over Immigration System. Now, what a white paper isn't law yet. Think of it like a detailed proposal. So, everything written, a blueprint of future immigration changes. But these proposals are significant and they aim to do one key thing: reduce net migration, tighten immigration controls. The Prime Minister Keir Starmer announced these proposed changes in response to what he described record high migration levels, with net migration having, and this is a striking figure, quadrupled. It is quadrupled in 2023, 4 times. So, what exactly is on the table? How could it impact those looking to live and work in the UK? Let's break it down simply. The cost of coming to the UK, the immigration skills charge. First up, let's talk about the cost specifically for businesses sponsoring skilled workers. This represents the current immigration skills charge, which is for small employers 364. So, this is the current immigration skills charge, 364 for small employers, and medium and large employers it is 1000. This per year of visa. This is a fee employers pay when they sponsor someone from outside the UK. So these are the fees: 364 for small employers and medium and large employers, 1000 per year of visa that they sponsor someone. So imagine this is the current fees and the government is going to increase a very hefty sum on it. It's 32%. So if these are the funds that a company has, they have to pour more funds into this ISC in order to bring someone to the UK. So they're going to bring it in line with the inflation. This is the first time this has gone up, the immigration skills charge, since 2017 when it was launched. So this is the situation. So it is going to be increasing considerably, and I'll tell the exact amount that it is going to increase to. For the small employers, it's going to increase to 480 instead of 364 per year. And for large employers, it's going to increase, large and medium, 1320 per year of visa. So that's a considerable increase, 32% increase. From 364, it's going to 480 for small employers. For medium and large employers, it would increase from 1000 to 1320, 1320. Remember, this charge is per year of visa. No one, very rarely I've seen an employer, very rarely, 1 in 100. No one applies for a skilled worker visa, no employer applies just for 1 year. Skilled worker visas are usually applied in blocks of 3 or 5 years. Yes, they can apply for 1 year, but no one does that. Hence the ISC cost, it has to be multiplied by the number of years, 1000 into 3, so 1320 into 3. And also the important changes is the ISC cannot be recovered from the employee. Very important. This will increase the business cost and it will deter employers from sponsoring someone on skilled worker visas. Now for businesses, this isn't a small bump. It's a significant additional cost when recruiting international talent. The idea behind it, according to the government, is to encourage businesses to invest more in the training for domestic workforce, someone in the UK, for the UK workforce. So that is all about ISC, which is increasing 32%. The part 2 settlement, indefinite leave to remain. Next, let's discuss one of the most impactful proposed changes, the qualifying period for indefinite leave to remain, often known as ILR or settlement in the UK. Think of ILR as gaining permanent residence in the UK. Under the current rules, anyone on the skilled worker route can apply for ILR after 5 years being in the UK for the continuous residence period. So imagine these are my beads. So 1, 2, 3, 4 and 5. So 5 years you spend in the UK and that's it, you are done. But what is going to happen as per the new proposals? They are going to extend this 5 into 10. You have to add 5 more years to this. 6, 7, 8, 9 and 10. So total 10 years instead of 5. It's quite a substantial change. They are going to double it. So instead of 5 years, it's going to increase to 10 years. That is what the proposal is. That's double the time. This is a substantial shift. Now there might be an opportunity to reduce this qualifying period based upon some unspecified points-based contributions. They have not specified it clearly, but there will be some points-based contribution to the UK economy and society. For example, doctors, nurses, AI experts will continue on the 5-year route. They are not going to go on the 10-year route. If you earn a particular minimum salary, I think from whatever I have the calculations, around 56,000 or 60,000 would be an ideal figure. I think they would be looking at. If you earn that, then you may be on the 5-year route. You won't go on the 10-year route. However, how long you need to earn that much salary, that is not very clear. We need to wait for the rules to clarify. But still, the number is not fixed. This is just as per my calculations. Around 56,000 was one of the number, and 60,000, something around that. The UK government's intention is to apply the 10-year ILR rules to even the existing skilled worker visa holders. Very important. That is the intention. How far they would be successful in achieving that is something to watch for. For my calculations, the 10-year ILR rules would tentatively be applicable once they are drafted, whoever they are going to be applicable on, from April next year, April 2026. So because there are a lot of steps now, consultations, parliamentary debates, etc., etc. So they will start and then it will take some time. Maybe April next year is what I am tentatively assuming that the new rules will come in. Also, I have seen several videos where individuals are claiming that if the government tries to put the new rule of 10 years on the current skilled workers who are already in the UK, then the government would lose in the courts. It would be similar to that HSMP judicial review that happened in 2008 on the basis of legitimate expectations. That is not entirely true. Let me just give a brief summary of what that was and what this is. In summary, what was that? The JR case. The Home Office was trying to apply new rules similar to the current position to the individuals who were already on the HSMP visa and they were on the 4-year route to settlement at that time. When they applied for the visa, they knew in 4 years we'll get ILR. They came to the UK and that was it. And then Home Office decided to change it and they tried to make it 5 years. And what happened? The Home Office tried to increase it to 5 years and with retrospective effect. So in the same way, someone who was already on the route was also required to meet that requirement. In the judicial review, the court found it in favor of the applicants, and the new rules, the 5-year requirement, did not apply to the individuals. That's what the judges agreed and decided, who were already on the HSMP visa. So yes, that is a precedent, but let's see how it differs as of today's situation. It only applied to the new applicants, and yes, Home Office let it go, and yes, it was a win for the applicants. But this is the crux of the matter. There were some other matters, but this is the main one that everyone is talking about in several videos. The main reason for the applicant's victory in that case was it was observed by the courts that when the applicants applied the HSMP visa, when they came to the UK, they had a legitimate expectation, a genuine expectation to get ILR in 4 years. However, you need to remember this point. It's very, very important. No one is talking about this. The day after the Home Office lost that JR case, around in 2008 sometime, they amended the terms of all visa application forms, the declarations, the terms that you sign, which you sign when you file any UK visa application when you come to the UK. Every UK visa application has that, which states that when you apply for any visa to the UK, you are agreeing that the UK immigration rules are subject to change. That was the addition that was made after losing. This is what Home Office does. They always change the forms anytime they lose cases in the courts. And on that basis, you have applied the first skilled worker visa. So that legitimate expectation argument is almost dead. You never expected, because you signed, that you can change the rules subsequently. And the courts would have a very hard time finding it in favor of the applicants, since the onus in any challenge would be on the applicant to prove that when he or she came to apply to come to the UK, the UK government had guaranteed them ILR in 5 years. So that is something that they should have guaranteed you, and it's very difficult to prove in the courts if you have already agreed that the rules can be subject to change. So what is changing is, from 5 years, the ILR is extending to 10 years with some exceptions, but we need to wait for the rules to be published. A huge question mark also hangs over transitional cases. What about those of you who have already started your 5-year journey towards ILR? Will the government be successful in implementing the changes on you? Will you be exempt from the new 10-year requirement? The white paper doesn't explicitly say all of this, and this is causing understandable anxiety for many. We'll be watching very closely for further clarifications on this. If you wish to receive updates, hit the link in the description to join our email list, and we'll send you the updates. Now, if you wish to work with me to solve your UK visa problems, ask your questions and build your UK visa strategy, then hit the link in the description for the proven consultation. As I say, that proven consultation and advice session is always gold. It's very important for your particular case. You can take a personal advice. Link is in the description. Next, the skilled worker route, raising the bar. The skilled worker route itself is seeing some significant proposed changes. Raising the skill level, that's the main one that we are starting with. Currently, the skilled worker visa can be sponsored for roles at RQF level 3. So RQF level 3, which is roughly about RQF 3 A level equivalent, A levels in the UK. So I think about A levels at 12 standard or something. Yeah. So RQF level 3 A levels. So that is the level of the job, not the education. And so this is the history behind how this RQF level changes have happened. In 2020, that is just after Brexit, the government lowered the skill levels from RQF 6 to 3. That's what they did. That is, currently it is 3, which led to an increase in work visas. Now the aim to raise the minimum skill level back to RQF 6. So what the government did, it was already at 6 before 2020. In 2020, they lowered it to 3, and then now they are again bringing it back to 6. So that is a goal. So RQF 6 jobs are graduate level jobs. They are not A level jobs. So approximately about 171 job codes would be out. I think that's what approximate calculation is on the skilled workers, from the skilled workers sponsorship possibility, skilled worker occupations being able to sponsor. What does this mean in practical terms? It means fewer job roles will be eligible for sponsorship. The government states this change is to address concerns about exploitation of overseas recruits and an over-reliance on international recruitment. Rather than sourcing talent from within UK, all the companies are over-reliant on international talent. So that is one of the main goals, and whatever the abuse happened on the skilled worker area. The good news for existing skilled worker visa holders is that the white paper confirms this raised threshold of RQF 6 will apply to new applicants only. So that is a relief. Current applicants who are already in the UK, you will still continue on RQF level 3. If you already hold a skilled worker visa, you can continue to extend your skilled worker visa or change employment on your current skilled worker visa at RQF 3 level jobs. And also you can take supplementary employment in current eligible occupations codes below RQF level 6. So you can continue at RQF 3, additional job, main job, changing employers, whatever you are doing. So that is a good news for current employers with raising the skill level. Raising the salary threshold. Now coming to the salary threshold. The white paper also confirms that salary thresholds for the skilled worker route will increase. No specific figures have been provided yet. But given the overall direction of these proposals, we can expect them to be higher, definitely higher. Abolishing, the third point, abolishing the immigration salary list, ISL. Currently, there is a list called as immigration salary list. What is that list? Which provides a salary discount for certain eligible occupation codes. For example, let's say care worker, I think healthcare jobs are there, nurses are there. This list is proposed to be abolished. They will just completely throw away that list. The government has asked the Migration Advisory Committee to review current salary requirements and discounts to ensure they reflect these changes. This means less flexibility for employers and potentially higher salary requirements across the board. So those are the changes coming in. Now coming to the English language requirements. We've talked about skill level, other things. Now coming to the English language requirement, this is completely new, never happened ever. A new standard. Now talking about that English language requirement. The English language requirement is also set to become stricter. So how is it becoming stricter? Currently the standard is B1 level. Any skilled worker wants to come to the UK, they have to pass B1 level in all 4 components. Reading, writing, speaking, listening, yeah, 4 components. But now it is being increasing to B2. So the B1 level is about intermediate level of English. B2 is higher, upper intermediate, you can say, skilled worker route. So the minimum proficiency is going to increase from B1 level to B2 level in all 4 components. So to put this in perspective, B1 means you can understand the main points of clear standard input on familiar matters. Clear standard input on familiar matters, if you can understand that. B2, which is a higher level, means you can interact with a degree of fluency and spontaneity that makes regular interaction with native speakers, native British speakers, quite possible without strain on for either party. It's not a noticeable step up, but still it is a step up. So remember that it is a slightly higher requirement. Okay, so the next, here's another significant change. So this is for the main applicant that I talked about from B1 to B2. The bigger change that is coming, which never happened, which I did suggest, is the English language requirement will extend to all adult dependents, whoever is over 18 years of age. Yes, that's right, partners and adult family members who accompany the main applicant. They will need to meet a minimum of A1 basic user level, and it doesn't stop there. They will be required to show progression for visa extensions. So first time A1, at the extension A2, and for settlement B2. So it is in line with the spouse visa for the British citizens. Currently dependents don't have any English language requirement. They may not be knowing English at all, that's fine, but that is going to change significantly. So the government is prioritizing integration into the British society for the dependents as well. If you are getting value in this video, please give a like, subscribe to the channel for more videos on UK visas, etc. Continuing from there, the graduate route visa, a shorter stay for our international students who complete their degrees in the UK. The most popular graduate visa is also facing changes. Currently, the graduate visa allows graduates to stay and work in the UK for 2 years. So any international student in the UK who completes a graduate level course, they can stay in the UK for 2 years, look for work, take work experience, do whatever other. So that is changing. The proposal is to reduce from the current 2 years is going to reduce to 18 months. The proposal is to reduce this period from 2 years to 18 months. So remember that that's a considerable effect, because anyways they have very less time, graduates. 2 years was anyways short, to find another employer or think of their career prospects ahead. And now reducing that to 18 months is going to be a real squeeze on the graduates. This is crucial change for many who rely on this route to gain work experience. So graduates rely on this for work experience or transition into sponsored employment. They will have lesser time to find a sponsor. Given the proposed fee increases, the salary threshold changes to the skilled worker route, many employers may now consider switching their graduate route visa holders as soon as possible. So if you are an employer trying to have a graduate route visa holder working with you, try to switch them as soon as possible before the changes come in, the fees increase, etc., etc. With the higher fees, stricter rules and all. So this is one of the suggestions that I can make, which would come into effect maybe this year with the fees increases at least. So what happens next and what should you do? So these are significant proposals. It's important to remember they are not immediate changes. Very important. People are assuming this will just definitely happen. This is a white paper, so it is just a proposal. It will need to be assessed and debated in the parliament. Not everything will pass through. Before any of these changes come into effect, it has to be passed and debated in the parliament. Some changes might be introduced in the coming weeks, while others will be phased over the course of this parliament. That's what has been confirmed in the white paper, over the course of the parliament, which means between now and 2029. We are in 2025, 4 years. So the whole parliament term. So quite a long term. There is still little detail on the exact timelines and how transitional cases will be handled, especially for the ILR qualifying period, the 10-year one. There is uncertainty, yeah, but I have given whatever my inputs are, whatever my observations are, and the knowledge and experience that I have. So what are the practical steps you or your employer should consider right now? So I'll just throw out some practical steps that will help you all. Review workforce needs. If you are an employer, conduct an internal audit. Identify roles filled by or potentially filled by skilled worker visa holders. How might these proposed changes like higher English language and skill levels affect your future recruitment? Communicate with existing skilled workers. If you are an employer, provide assurance to your current sponsored workers. I know I'm getting so many inquiries on YouTube everywhere. Skilled worker holders are worried. So assure your sponsored workers. Discuss potential impacts and what steps you plan to take. If you are a skilled worker, stay informed and discuss with your employer. So if you are a skilled worker, rather than asking me, talk to your employer, try to work with them as well. Review current recruitment strategies. Where possible, consider expediting recruitment and sponsorship of skilled workers before increased fees take effect. Review recruitment budgets, start preparing for potential increases in visa application fees and overall costs associated with sponsoring skilled workers, as you cannot recover it from the employees. Conclusion. The UK immigration system is evolving as always, and these proposed changes, if implemented, will make it more challenging and costly for many. We at Visa Solutions are here to help you navigate these complexities. We will continue to monitor these developments very closely and provide you with updates as soon as they become available. If you wish to receive regular updates, join our mailing list. Hit the link in the description. You will receive regular document checklists, latest UK immigration updates, exclusive free advice sessions that we run in between. Email advice is anyways free that we try to provide. So send us email with your questions. We will try whatever we can. Yeah. Detailed eligibility requirements, helpful tips, successful applications for successful applications. Yes, join our mailing list. If you have any questions about your specific circumstances, please remember this video just provides a general guidance. It's vital to seek specialist advice tailored to your situation, and that is book your proven consultation and advice session. Link is in the description. Hit that. I say it is always gold. Book the consultation for your specific situations. Now that you have understood the UK government's white paper in simple words, if you wish to know more about the importance of expired BRPs, the cards expired, but what is the importance of expired BRPs, why you should hold on to them, watch this video over here. If you like this video, subscribe to our channel, give a thumbs up and keep watching. Thank you very much.